Guy has brought some of his books for sale here, so I would encourage you to lighten this load
Yeah.
on the trip back.
So and my friend Al, too.
Yeah. Okay, so it's unanimous, basically. Guy, someone I've been trying to get in Chicago to have speak for many years. And the president was able to do it, so that's good. He's one of the great Lincoln legal scholars of our time. He's been speaking about Lincoln, the lawyer, and Lincoln, the lawyer on the Eighth Circuit in particular, for many years now. He's written books on the subject. I like to think he's considered the foremost authority on the subject.
Thank you, sir.
Yes. And he speaks quite often at the Lincoln Association meetings and many other events that many of you have attended. So without further ado, I give you Guy Fraker.
Could we move this out a little bit? Could we move this out a little bit?
This way?
Yeah, I feel like I'm back in the weeds here.
Just tell me where I...
Keep going a little more. And then just... Okay. Now my agility is illustrated. And yours too.
My feet are all... Yeah.
Wait a minute.
Can I move this forward here?
Yeah, please. I think, is that mic mine that's making that noise?
Yeah. There we go.
Can you hear me with, well, let me take this off. Can you, okay, all right, okay. Yes, let me start out, as you might expect, by thanking Bruce and the WRT of Chicago to have me here. It's a real privilege. That there's no organization in America that sustains and encourages and feeds the history of the Civil War, probably our most dramatic war and perhaps impactful war. But no, not probably, it was. And of course, its principal character, there are several of them, but the principal character is, of course, Abraham Lincoln. So I'm glad to talk to him, talk about him. And today, it's a subject that's near and dear to my heart as a Central Illinois lawyer. But by the way, how many people here are lawyers? Let's have a raise of hands. Because Lincoln's practice as a lawyer is a large part of what formed him and made him the man that we know. He was, let me get back to my notes. The focus of his law practice was being a lawyer. It was not he was not a cause lawyer. He didn't decide to take cases because of the cause represented by his client. He took cases because he was making a living as a lawyer. And I'll go through various cases he had, which will maybe, if you haven't heard about him, one in particular will shock you, but I think it goes with that premise. He was a self-taught lawyer. He as was already, some of this you've heard these numbers before, but he came to New Salem in 32. He was there till 37, and then went to Springfield, where he practiced law for 23 years. He became a lawyer from reading. Somehow he got hold of a copy of Blackstone's Commentaries, which was always, both in England and in America, the primer for the law in that era. He also he became friendly with John Todd Stewart, whose name was mentioned earlier, and Stewart loaned him some books. So he read these books on his own in New Salem. And the custom in the day was that you became a lawyer by being an intern, so to speak, in a law firm, and eventually you were interviewed the way Lincoln was, but by people after you finished your training, and then you became a lawyer. There was no bar association or bar exam or anything like that. Lincoln proudly wrote in an autobiography that he studied law alone. He did it by himself. He didn't have any help other than his study of these books. In 37, he goes off to to become a lawyer in Springfield, Illinois. He had three partners. They were mentioned briefly, but I think they say a lot about Lincoln. Lincoln was very intentional in his law practice. By that I mean building a law practice and associating with the right people. And that's best illustrated by his three partners. The first one was John Todd Stewart, who, by coincidence, it had nothing to do with Mary Lincoln other than that, just by coincidence. It was a cousin of hers. Stewart was probably the most popular lawyer on the circuit, so Lincoln needed to become known. So he worked with Stewart for 4 years, becoming more widely known because Stewart knew everybody. But Stewart was not much of a lawyer, I mean, not a bad lawyer, but he was so busy with politics, Lincoln wasn't learning much about being a lawyer. So his next partner was Stephen T. Logan, a native of Kentucky, who was, according to David Davis, the judge that we'll talk more about later, he was the finest lawyer on the circuit. And they were partners for 3 years till 44. Lincoln was there to become a better lawyer. Having been so served by his association with Logan, then he partnered with William Herndon. Mary never accepted that. She thought Herndon was beneath him. But Herndon was a fine lawyer, because he was always the junior partner, so to speak, people don't appreciate what a fine lawyer he was in his own right. But he was what Lincoln needed, a guy who could back him up while he was doing all these other things. In all these cases we'll be talking about, he needed an associate, so to speak, and that was Herndon. And that relationship lasted until Lincoln went off to Washington. And a touching story, he went in to see Herndon on his last day in Springfield, and they had a plaque hanging outside the office, Lincoln and Herndon. He said, "Leave that up because I'll be back," which, of course, ironically, he was never. Those were his partners. Then the next question is, where would he go as a lawyer? He went to Central Illinois and the Eighth Judicial Circuit. Real quick, you probably know what circuits are. The courts are organized with a certain number of counties in a circuit. The Lincoln Circuit was the Eighth Judicial Circuit, where he practiced. It was formed in 1939, 2 years after he started, and that was always where his practice was. And the real emphasis of his practice was there. And that was an important part of this. So the location. Now you would say, well, wait a minute. They're down there in the boondocks in Central Illinois, said the Central Illinois lawyer. But the reason was it was sort of the going place in the state at that time. The state was growing. The population had started from the south, Kentucky and Tennessee. So the lower part of the state was very conservative and soft on slavery. Then Easterners came in to the upper part of the state, and that generated another attitude towards slavery and those issues. And all of these two met in Central Illinois in the Eighth Judicial Circuit. So that tempered him as far as being radically taking any position on that issue. The size of the circuit, he wrote it, he went twice a year, and it was later on railroads, when the railroads came in 1853. But before that, it was on horseback, usually on a horse without a carriage in the spring, because the roads were so bad, the quote roads, there were more tracks than roads. And it started in late March. It included my focus of this map you have here is 47 to 53. That was the height of the period where he was riding horseback. In the spring, he would take a horse. In the fall, because of the dry weather, the roads more reliable, and he went in a carriage. The size of the two constants here about the wonder of Lincoln's choosing this area to practice in. This place was, Central Illinois was not a backwater, but it was not really part of the national culture when Lincoln got there. But the growth in the circuit was paralleled his growth as a person. So he developed in a place that was growing and became probably the most important part of the state through the period before the Civil War. I've got the numbers here for you. In 1840, the population of the 14 counties was 70,000. The population of Cook County was 10,000. In 1850, 107,000 versus a mere 43,000. In 1860, 230 compared to 150. So this really was where the action was. The circuit was depicted in this map. Was he traveled twice a year, as I said. In the spring, he left Springfield, and after you started in Springfield, he left there in March, and he didn't get back till June. So it was 3 months on the circuit, roughly. In the fall, in August, it started, and it went to November. So, and he was virtually, he was the only lawyer that always was out on the circuit. He did all 14 counties. Most of them did 2 or 3. There wasn't enough business in any one of these towns, so they all, at least the trial lawyers, fanned out slightly, a couple of counties here and a couple of counties on the other side, but none of them did the whole circuit, with the exception of Lincoln and a man named Leonard Swett, whose name is going to come up constantly in this story. The circuit, the ride around the circuit was 400 to 500. The circuit held 400 to 500 square miles. It was twice the size of Connecticut, and it was approximately, depending on which roads they had to take because of the roads, 400 to 500 miles around. And it was very strenuous being out there in all kinds of weather because you had to get to court. You couldn't just wait till the rain stopped. And so it was pretty vigorous, and he had to be quite a horseman, and he had to be tough to be a circuit lawyer the way he stayed. He stayed out, as I say, on the weekends. He didn't go home. There's various theories for that. One is because it was home, and but that's another argument I don't want to get into. But I think he was more purposeful in that. He stayed out there when all the other guys went home. He stayed out there to get to know people, become acquainted with people. And the result of his time spent in each of these towns, they sort of, Bloomington, for example, they considered him one of their own because he was so often in that town and had so many personal relationships, which would serve him throughout this story that we're telling. His practice was amazingly broad. He was a real lawyer. That's what makes me so proud, and that's why I asked all the lawyers here to raise their hand, because the best training that he had was being a lawyer, and we can all be very proud of that. I've got a list of the range of cases, and it's pretty astounding, the cases that he had. Collections were a big deal, and you say collection work. Lawyers don't think of collection work being a big deal, but in those days there was not enough currency for the economy, so promissory notes were used. So A would give a note to B for goods. B would discount that note and give it to C, and then D, and then maybe D didn't pay it. So the first guy, the lender sued D, who he never even knew. So that created a tremendous amount of business. But the other one is contracts. Breach of contract. There were so few statutes in those days, so business conduct was governed pretty much by lawsuits, by honoring by their contracts and the honoring of those contracts. So that was a major part of his business. Not exciting stuff, but a good source of business. Next came real estate. He had 1,750 cases involving real estate titles, partition suits, which are fights over division of property and so forth. So that was a major part of it. Third was wills and inheritance. He handled estates. Wills were often not skillfully drawn, even more time. There were no wills, so you had inheritance by statute, and so that was a great source of his business. Next was defamation. I want you to hear this, particularly ladies. the suits involving defamation, he had 85 cases. I mean, I practiced law for 50 years. I don't think I saw one. But it was serious business at the time because honor meant a great deal to people. The suits involving men, the defamation cases, were about business, about dishonesty, about lying in business. The suits about defamation about women was almost all about chastity. That was the issue. And accusations of bad behavior and so forth. Then the next one, this is not that important, except it's amazing how times change. He had 9 seduction cases. Now, a seduction case you'd think might be the poor young girl suing the guy that made her a mother, but it wasn't. It was the father of the girl that was suing the bad guy for loss of his daughter's services. So things are better. Personal injury, which we know a lot about now, very little personal injury work then. There very little. You know how much the negligence and tort cases now involve the courts, but very few. I want to mention 2, though, that were unusual. One was Dalby versus the Illinois Central, which was a significant case. Dalby was a passenger on an Illinois Central train that was behaving badly, so the conductor stopped the train and threw him off the train, injuring him. So he sued the railroad. He did. Lincoln sued the railroad, and he sued him. You could sue the conductor, of course, that was a given, but how do you sue the railroad? The railroad had nothing to do with it. Well, it did, because their agent committed so that's called vicarious liability, and that case was a principal source of vicarious liability in the state of Illinois. The other one is suing the government. The old law of the 19th century and before, the king can do no wrong, so it was very difficult to bring a suit against governments. A man fell through a board sidewalk in Springfield and sued the city of Springfield. Springfield claimed immunity, but the court, this all goes to the Supreme Court. The court decided that when a city or a government undertakes to do something like creating a condition, then they're responsible for its condition. So that was a case. One of my favorites is a malpractice case that he had in Bloomington. This chimney had fallen on a guy in his 50s during a fire that the guy was witnessing. And so the guy went to Dr. Carruthers, who was a prominent doctor, to have his leg set. Well, it didn't turn out too good. So I can't imagine this. Carruthers had him in to reset it. So he broke it again to reset it. And the injured man, in screaming in pain because of this procedure, just ran out and was left with his leg. So he sued the doctor. Lincoln represented the doctor, and Leonard Swett, there's his name again, Leonard Swett defended the case. There was a hung jury, and so after it was set for retrial, the case was settled. That was an unusual type of case. Criminal cases, of course, we hear a lot about the criminal cases. It was only 5% of his practice. A couple that I want to mention, a couple of those cases. He by the way, had 27 murder cases. 27 over 23 years doesn't sound like a lot, but when I think of the responsibility, a murder case, your client was going to get hung if it didn't come out right. So taking on that responsibility 29 times is pretty amazing. One of those cases was People versus Armstrong, which was a case where it's the famous Moonlight case that you may have heard of. This man fell off a horse. He claimed he'd been knocked off the horse by Armstrong. Duff Armstrong was the son of the Armstrongs of New Salem fame, so they had long ties. So Lincoln defended him, and the plaintiff, this took place, had a witness that saw it happen, saw him get knocked off the horse. So in cross-examination, Lincoln said, well, it was after a camp meeting. It was in the middle of the night. How'd you see that? And he said, well, the moon was so bright. I could see it in the moonlight. So Lincoln famously introduced the almanac that showed there was no moon that night and got him acquitted. That's one. Another one is one I like particularly because, again, it reflects on the times. This was in Woodford County, which is Metamora. And by the way, we'll go over the circuit, but Metamora was the county seat at the time. And the Metamora Courthouse still stands, and it's worth a trip up there to see it. Because this place, it's still as it was, and the courtroom has been restored the way it was. And the room where this happened, this woman was assaulted repeatedly by her husband. She finally got just sick and tired of it and didn't want to kill him. She just wanted to get him off her. So she had the nerve to grab a piece of firewood and hit him over the head. Well, we can't have husbands being beaten by their wives. He was killed. So she was tried for murder. And the judge was a woman, or was a man. The juries was all men. And we were expecting to convict somebody for killing her, acquit somebody for killing her husband. I don't think so. So Lincoln saw the case was going pretty bad. He took her downstairs on a recess, and she said, I'm very thirsty. This is the legend. He said, well, I know there's good water in the Tennessee River. He opened the window, and she was, and she ended up in California later. So that was that case. And finally, he had all kinds of suits involving injunctions and other issues. He represented county governments in much litigation. The point being, he had a broad, interesting practice. The main punch of this story is not so much, or that part of it, because it trained him, it made him who he was intellectually. But the guys that he practiced with in that Eighth Judicial Circuit, that's the real significant part of the story. David Davis was the judge. He came from Massachusetts, settled in Bloomington. In 1848, he became circuit judge. And by the way, the circuit judge, there was only one judge for the whole circuit. So the judge had to ride the whole time. Lincoln being the only lawyer that rode the whole time, they became quite close. But never, as somebody mentioned that those question and answers today, that Lincoln Lincoln would substitute for him, just on motions, sometimes on Lincoln's cases, and trusted Lincoln to rule on his own cases. But nobody ever questioned that. And there was no reason to. These men were of the highest integrity. Here, let's look at the circuit map for a while, just so you'll see what we're talking about. Sangamon County is there. That was Springfield, the town capital, the state capital. From there, he goes north to Tazewell County. And by the way, the crosshatching is his district when he was in Congress. So he goes up to Tazewell County, then up to Woodford County. Tazewell Tremont was the county seat. Then it became Pekin. Woodford County was Metamora, but ultimately it became what is this county seat of Woodford? Well, it doesn't matter because it's not part of Lincoln's story. But anyway, that was Metamora. Then he came to Bloomington, very important in the story. Then he went to DeWitt County, which is Clinton, or to Logan first, and then from Logan to DeWitt County. Logan is very important in the whole Lincoln story. From there to Piatt County, Monticello, from there to Champaign County, which is Urbana, then Vermilion, which is Danville, then down to Edgar County, which is Paris. Then, oddly enough, a lot of historians in the early 19th century said Charleston was part of the circuit because it was surrounded by three sides, but it wasn't. Then to Moultrie County, which is Sullivan, then to Shelby County, Shelbyville, then to Macon County, then which is Decatur, then Christian County, which, by the way, this is interesting. It was called, it initially was called Dane County, was the first name for it. Only county that ever had its name changed. Dane was the man that voted on the 1798 legislation for creating the territory, the Northwest Territory, voted that put in an amendment to keep slavery out of that. So all the Northwest Territory, all the states we think of, Ohio, Indiana, so on, were because of Dane. So they named the county Dane. And the people of Christian County were so outraged that this man who was so staunchly against slavery, so with Lincoln's help, they got the name changed to Christian County. And that's uncharacteristic, but that's Lincoln doing what he was hired to do. And then finally, after Christian, home to Decatur. The lawyers, now that you see the map, I want to talk about some of the lawyers. We've already mentioned Davis being the judge. Sangamon County was Names Conkling, Matheny. They were McLean County. McLean County was the most important in its support of Lincoln throughout his political career because of David Davis. But the attorneys included a guy named Gridley, who I wish I had more time to talk about. Gridley was the first millionaire in McLean County. And he was a heavy drinker, and he'd just go out sometimes on the street and start cursing at people. But he was a friend of Lincoln's. Lincoln represented him on many cases, and this is another illustration. He gave, there's one biography which people question, but it says he supplied Lincoln with over $200,000 in all his campaigns. Jesse Fell is a name that I wish I could talk more about. He was prominent in the Lincoln story. He was a Quaker, and very devout Quaker at that, but he was sort of the liberal in Lincoln's circle on slavery. Leonard Swett, I've mentioned, he was maybe the best lawyer on the circuit. He came from Maine, ended up, fought in the Mexican War, kind of drifted into Bloomington, sort of at loose, not know what he was going to do with his life, runs into David Davis, becomes a judge. And you people will be happy to know that after the Civil War and the Lincoln's assassination, he was Davis's right-hand man at that convention. But after that, he came to Chicago and practiced law. He was a very prominent criminal lawyer in Chicago for many years, till the 1880s. Champaign County, a guy named Cunningham. If you think about it, there's a Cunningham Street there. There's a Cunningham orphanage. He's very prominent. The last man on the circuit that rode the circuit. Then we go to Vermilion County, and that allows me to tell a story about that. All these towns had taverns where they stayed, and a tavern implies booze, but it wasn't. I mean, there was a lot of booze, but not. Lincoln never drank, and the tavern was an inn, in effect. And all these guys slept 2 or 3 to a bed on the floor. But this was one of the best. And the McCormick House, it was called, and everybody loved to go to the McCormick House. And Lincoln was a great joke teller. This will be a constant to my talk. Lincoln was a great joke teller, but a lot of this took place after court in the restaurant or bar room of the hotels. And the McCormick House is one that has a personal account of Lincoln's performance there, totally cracking up the whole crowd. And you all know Doris Kearns Goodwin. I was involved with a show that for U of I that we did, and she was one of our talking heads. And she said, and wistfully, she said, if one thing I wished my whole life is that I could go back to one of those taverns and be there to watch Lincoln perform in those taverns. The way she said it was quite moving. This opens it up for me to give you just one joke that, you think about your own life. You tell jokes your whole life, but nobody records them. So there's very few actual jokes that Lincoln told. Most of them were bawdy, so they can't repeat it anyway. But this is the closest. This is from Doris Kearns Goodwin, and it's the closest that I can come to bawdy. This farm boy comes running in to his dad's house on the farmhouse, and says, Pa, you better get out to the barn, because sister's out there with her boyfriend, and she's pulling up her skirt, and he's taking off his pants. I think they're going to pee in the hay. And Dad said, son, I think you have your facts straight, but I think your conclusions are wrong. But you know, any of you lawyers, you've had cases where the facts are not disputed, but the law is. So you can see him using that in a closing argument. I don't know if that's true or not, but that would fit that. But anyway, that's about his humor. The amazing thing that impacted Lincoln, as it did the whole area, was the coming of the railroads. The railroads arrived in 1853, and that changed the whole area. One of the historians, county historians, said it was the end of the pioneer era. Another one said that it was the Enlightenment, the Awakenment was what they call it. It totally changed the culture. So here's where Lincoln's ability to grow. He became a railroad lawyer. He involved heavily in litigation, and I'll talk about one case in particular. But I made a score sheet. He took 71 cases on behalf of railroads, and then he took 62 against railroads. So there again, we see this pattern. He wasn't a crusader for railroads. He's taken whoever comes to him first, and that was an important part of his practice. My favorite case, and it's actually his most important case, money-wise, the state of Illinois gave us to get the Illinois Central to go through the whole, down the middle of the state gave them a section, 640 acres, on each side, alternating all the way down the state, a huge amount of real estate. The bill creating that transaction also exempted them from county taxation. Well, as you know, county taxes, real estate taxes are the major source of revenue for counties. So Champaign County contacted Lincoln and wanted him to handle this case against the railroads, against the constitutionality of that legislation. And so Lincoln said he would consider it, but he was interested in taking the case for the county. And then along comes Illinois Central and says, Mr. Lincoln, we'd like you to represent our interests in this case. And Lincoln said, well, I've already sort of talked to Champaign County, but I tell you what, let me talk to him. So he went back to them, and this is why I love this story so much. He said, if you'll pay me as much as the railroad, I'll take your side of the case. And he did take the railroad case, and they exempted they upheld the exemption. Lincoln's had a fee of $5,000. I went and whatever you would call it, made it current, made the value current, and that was $160,000. In the Douglas campaign, Douglas accused him, that was the one he ran against each other for the Senate, of being a tool of the railroads because they bribed him with his $5,000 fee. And Lincoln said, that was no bribe. That case saved the railroad $500,000. Well, I projected that out. That was $11 billion, and that's how important that case was. So the importance of the circuit to Lincoln, this is another aspect of it that I never really thought of till I went to the home, to Mount Pelier, in Madison's home. And I was there with an African American and a bunch of guys. We were going to Gettysburg, and we'd always take these side trips. And the woman took us up, the docent took us upstairs, and then in the room, and she said, I hope that's not mine. Okay. They took him there, and this is his reading room. This is where Madison spent 4 years reading 200 books to prepare himself for the Constitutional Convention. And this black man leans over to me and said, I wonder why I had that much time to do that, which is a great point. So that got me to thinking, well, Lincoln didn't have any slaves to do his work. Where did he have the time to think and become probably our greatest thinker? It was on the circuit. That's how important the circuit was. Sometimes he'd ride with these guys and tell jokes and everything. Other times he'd withdraw, go off and read frequently some very heady stuff, but mostly just think. So that's a part of the importance of the circuit. The relationships he built served him so well in the punchline, which is going to be the end of this talk. And he could practice politics. Who can afford to travel all over the state or any part of the state if they have to work for a living? How can they also give speeches? But Lincoln used his circuit appearances to be in the county courts, and maybe in the daytime he'd try a case in the circuit court in the courtroom, and then that night he'd be back in the courtroom giving a political speech. So that's the importance also. And he built such relationships, which is none of the guys had in 1860, which gets me to the convention. And many of you know this story, but I think it's worth repeating. It was the 1860 convention. It was held in Chicago, and there was a heavy favorite. William Seward was a heavy favorite. I have a copy of Harper's Weekly from May 6th, 1860. And it tells the story. Right there in the middle, like the sun, is Seward, William Seward, who was governor and senator. As the planets would be around the edge of this picture, are 10 people. One of them is Lincoln. So that tells you, when that convention was starting, where Lincoln's chances stood as far as the quote, the media. David Davis got a hotel room at the Tremont Hotel, which was the headquarters. He pulled together all these lawyers from the circuit that had known Lincoln well and knew him well, and he organized them to take on this campaign. For example, just as a few examples, Samuel Parks from Logan County had come from Vermont, so okay, you take a Vermont delegation. Sweat, that I mentioned, was from Maine. You take Maine, and then Jesse Fell was from Pennsylvania. You take Pennsylvania. Richard Oglesby, not Ogilvy, Oglesby, was, or whichever one it wasn't. I can't. But anyway, he was from Kentucky. Okay, you take Kentucky. Logan took Kentucky, and so on and so forth. So these guys fanned out, and by hook or by crook, they ended up, there were 18 lawyers that helped this effort at the convention. A final note of that convention that's sort of interesting. I'm going to give you, let's see, the balloting is interesting. Let's see. There were the first ballot. Seward's or Davis's goal at that convention, they knew Seward was going to be a heavy favorite, have most of the votes. They just hoped they could stop him on the first ballot, which they did. Lincoln wanted to become the best of the rest with these other 10 floating around out there, and so they hoped Lincoln could get 100 in the first ballot. He got 102. Comes the second ballot, and Pennsylvania, which was the largest, next to New York, was the largest delegation. Pennsylvania had their crooked governor, Simon Cameron, as a presidential candidate. And so their votes were dedicated to him. Sweat and Davis spent the whole night almost with the Pennsylvania delegation. And within Davis's pocket is a telegram from Lincoln that says, "Make no deals that will bind me." So what does he do? He goes out and makes a deal with Pennsylvania and he said, Lincoln ain't here, which was true. The candidates never went to the convention. Lincoln ain't here, so he doesn't know what we have to do. So he makes a deal to make Simon Cameron Secretary of War, or a cabinet member, which turned out to be Secretary of War. And when the Pennsylvania ballots swung over, then that pulled Lincoln within 5, like 186 to 181. And then the third ballot, Ohio split, which was amazing because one of the main candidates was Chase from Ohio, split, and that put Lincoln over the top. So Lincoln is, because of the circuit and his relations in the circuit, that Lincoln became the nominee. As you know, because of the Democrats being off split over all these issues, he became President of the United States. Now this makes a great story, and because he clearly won, but there's two things I want you to think about, and I should have mentioned this earlier, but let me finish this thought, and then I'll give you one final thought. If that election hadn't happened, if these events I just told you about hadn't happened, this country would be two countries, and if this country split, then pretty soon the new country, oh yeah, we might as well split. We don't like what they're doing over there on the East Coast down south here. We're over here in Mississippi. Let's us split off. Democracy was this was the only democracy in the world. If the South succeeded, then democracy is a severe blow to democracy. That's the importance of this circuit. Finally, then I do want to mention, back to contracts, Lincoln all along, this is on the issue of slavery, all along Lincoln was a conservative. He said that he wanted to see slavery stay where it was. He did not want to see it expanded. And he said the reason for that is this country is based on the deal that was made in 1789, that the South could have its slavery, but the slave trade would stop importing in 2008, but in return for that, they will not leave. They'll be part of the Union. That's the trade, because the South was threatening to secede unless if slavery ever passed. So I'll keep my deal. I won't go for the elimination of slavery. You stay in the Union. Okay, that was Lincoln. And that was, in a sense, a contract, a deal he made. But when the South seceded, they breached the contract. And that justified the Emancipation Proclamation. And we all know the consequences of that. So thanks, and I'll answer any questions you might have.
Okay, do we have any questions, comment? Yes.
Yeah, how successful wasn't Lincoln in his court cases?
That's a good question. There are 5,000, as were mentioned earlier. Some of these, but how do you judge a win? In a criminal case, it's acquittal.
Yes.
But in a suit for damages, maybe the plaintiff, and we all went through this, we lawyers, here's a case that's worth 100,000, those numbers wouldn't have been true. Here's a case that's worth 5,000. I'm going to try it though. I don't think it's worth that much. And then they try and they get 3,000. So they got less, but that was a loss if you count it, because the plaintiff, Lincoln, lost as a defense lawyer. So you can't really go by that one loss record. It's hard to answer that, except all the testimony is what a fine lawyer he was. And it was earlier mentioned that he had 400 cases in the Supreme Court. Now that sounds like a lot, which it was, but there were no appellate courts in those days. Now most appeals go to the appellate courts, very few get Supreme Court. But in those 400 cases, most of them were referrals from all over the state, because he was there in Springfield to handle it. So that was a testimony to what a fine lawyer he was, and how lawyers all over the state considered him such.
Would you say at that time he was a preeminent lawyer for Illinois?
A preeminent, yes, because downstate, as I say, these guys were top notch that he was up against. And yes, I would say he was. And he was that was all business, though. He wasn't out there running around looking for causes. Do I have time? Do you want to hear about another case that bothers me about Lincoln, if I may?
Go for it.
Okay. There's a case that arose down in Charleston. I meant to mention this earlier. In Charleston, in Coles County. Let me get rid of this stuff. And this man came to Lincoln and wanted him to represent him. There was a woman that had been a slave that he brought up from Kentucky, and he wanted to take her back to Kentucky, but a do-gooder doctor in a small town near Charleston, this case was in Charleston, filed a habeas corpus to free her. And Lincoln took the case to have this man be able to take his slave back to, or his property back to Kentucky. And most people are appalled. I've seen he lost the case, happily. But I've seen a lot of explanations why he would do that. I think the answer is very simple. He was a lawyer hired to represent clients and not judge the morality of their position, and let the courts decide that. So that I'm very proud of the fact that he took that case, not embarrassed by it, because that's what lawyers do. And he also, he's no question about it being anti-slavery, but he took a case sort of defending the institution because a client hired him to do that, and didn't color his decision by the nature of the dispute. So I don't find anything there to argue about or criticize him for. I'm proud of that. Illustrates what kind of a lawyer he was. Yes, ma'am.
But that would have been prior to the fugitive slave law?
Fugitive slave law came in 1850, right. And this case was, I think it was in 57. And by the way, he defended some fugitive slaves cases. Another subject that is interesting, as long as, if you guys let me go on and on, to show his attitude. He never drank, as you know, but there's a case he took in DeWitt County. There was a tavern open that was legal, but a bunch of women, temperance crew, including the mayor's wife, went in with axes and broke up all the liquor and destroyed it. And they were charged with criminal damage to property. Lincoln, in that case, represented the ladies, and he lost the case. And David Davis fined them each $2. So, but then there are other cases where he defended people, men who selling liquor without a license, those kind of things. So there's another example of not going the way. So,
what did Lincoln reflect on, like, life on the road afterwards? That he missed?
no, never. That's what's very interesting and too bad. He, not even after. I mean, he never. There's nothing in his letters. There's nothing in his statements about the romantic circuit and you think of the prairies in those days. 8-foot prairie grass, beautiful flowers in the fall, especially beautiful time. But other times really rough. And some of the lawyers, one of them whose name escapes me now. But my wife, who read Moby Dick, and I said, don't bother reading all that stuff, just read the story. So she read it all and said, Guy, don't ever tell me what not to read. But Melville says in there that the ocean's waves reminded him of the prairie grass. And then this newspaper man from New England that came to the West said that the prairie grass waving reminded him of the waves in the ocean. It was a beautiful place, and also very difficult. But Lincoln never commented on that at all. Yes, sir.
A real quick question: was there ever a case that Lincoln had where he made a mistake? I mean, in his opinion, he made a mistake defending someone or somewhere in the procedural process of that case, and did he ever speak about that after the case was over? So in other words,
well, I think not. I think not. I don't know that, but I think I'd know about it because I have spent a lot of time reading them. But I don't think he ever publicly would acknowledge. There may have been some criticism of his handling, but I don't know what that would be. I don't know of any. But that's not to say that he didn't do it, because no lawyer is perfect, and he was a good one, but he wasn't perfect. Nice question, though. Yes, sir.
I believe Lincoln put Judge Davis on the Supreme Court later.
Correct.
Did Judge Davis ever comment in memoirs or reminiscences about life on the Eighth Circuit?
I'm glad you asked that question, yes. Because this is one of the strangest things ever that I've read about Lincoln. William Herndon wrote the first biography, and Rodney Davis and Dave Wilson, not Dave, at Knox College. Who?
Douglas Wilson.
Yeah, Doug, thank you. Douglas Wilson wrote this book called Herndon's Sources or something to that effect. And it's a it's not a book to go page to page to page, because it's all his sources, interviews, letters, so forth. But he's got this interview with David Davis, who they're supposedly so tight. This interview with David Davis was about a year after Lincoln's assassination. And he said he was a very peculiar person. He never shared his thoughts with you. You never knew what he was thinking. He was cold. And this really harsh commentary that he gave to Herndon. So that makes you wonder what in the world was the relationship. And
But yet he worked so hard to have him out.
yeah, but that may have been because he was the best candidate. And also, imagine the ego trip of getting a man elected president against Stephen A. Douglas.
Worked out for Davis.
Yeah, it did. Oh, yeah, that's true. And yeah, think about that also. To jump from the circuit court of I was bragging about what a major court it was, compared to what? Compared to courts in New York, Ohio, Pennsylvania. So to be elevated from the circuit court of the Eighth Judicial Circuit to the United States Supreme Court was not a bad jump.
I guess it's been political for a while, the Supreme Court.
Yes, yeah, yeah. Oh, no, is it still?
Not that I know of.
No, me either.
Any other questions? Okay.
Thank you all very much. Thank you. I've got some